Hello, everyone, and welcome back to Immigration and Jobs Talk Show. I'm your host, Nipasa Pradhan, and I'm really happy to welcome you folks. And before we start off with today's discussion, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, thank you so much for joining us today. We are streaming live right now on YouTube, LinkedIn, and on Facebook and on X. So please feel free to join us in this conversation by commenting, whatever questions you have, because we are going to have our guest attorney for today, and it's going to be great to have her for an hour where we can also address your questions. So, yes, thank you so much for joining us. And it's a very critical topic we are going to dive in today for all immigrants and their families. So, yes, with the release of January 2025 Visa Bulletin, many of us are wondering, what does it mean for us and our loved ones and our future plans, right? And we're going to unpack this for sure. But before that, please help me welcome a very special guest, Attorney Prashanthi Reddy. She is a leading expert in immigration law with years of experience, guiding individuals and businesses through the complexities of US immigration process. Thank you so much, Prashanthi, for joining us today.
Hi, Nipasa. It's good to be back.
Absolutely. And friends, we have a breaking news regarding the upcoming H-1B regulations effective January 17. And there are new changes that aim to streamline, the process and address key compliance issues, raising questions about the impact on both employers and employees. So, Prashanti, before we really dive into our topic for today, I have this question. If you could tell us, what are the key changes in the new H-1B regulations effective January 17th, 2025?
Right. We had an idea that this was coming, but was coming because they did publish the regulation in the Federal Register, but then they have a comment period, so they were waiting for comments. And then based on the comments, they often change the final regulation. So this is the final regulation, and it's already published, and it was published yesterday, the 17th, is effective 30 days from January 17th. Guys, ladies and gentlemen, it is now official. And this will be the final regulation. And this is a big deal because for a while there hasn't been any regulation on H1B. At least there hasn't been a comprehensive regulation such as this on the H1Bs. So this is a big deal, and that's why we're bringing it to you as breaking news. So let's dive right into what, and there's some very interesting things and path-breaking changes that you'll see, and some of them are, more of what you saw in the past, which is just being regularized now, because of case law and lawsuits, they were not able to implement. So we knew that it was coming, and some of the aspects of this regulation are completely new and path breaking. So let's dive right into it.
Sure.
As I said, the final rule was and significant changes to the H1B program have been introduced in this rule. And as I said, 30 days to take effect. So we're talking about January 17th, just days before the Trump administration will take over. And this was done deliberately because they wanted to put it in before the Trump administration came in so that it'll be difficult now for the Trump administration to make their own rules. This is the rules that the present government wants to have, right? It's good and bad. It's not like the Democratic government is completely free on H1s. No government is. Um, so but at least it's a mixed bag, right? So under the Trump administration, if, in my opinion, if they wouldn't have passed any regulation, then the Trump administration would have passed a much stricter regulation. So let's go right to it. First is they're giving deference to previously approved cases. So if you're filing a extension or an amendment, and if it's been approved previously, and if nothing has changed, if there are no new material changes, then USCIS will automatically approve those cases without again sending requests for further evidence. So that's called the deference policy, which is, I mean, already supposed to be there, but now they're putting it into regulation, so it'll be implemented for sure. They've updated the definition of specialty occupation. This rule revises the definition of what a specialty occupation is. This is the very core of who can get a H1 by revising the definition. That has a significant impact. So they've broadened the range of degree fields related. So right now, as per the regulation, a specialty occupation is an occupation where a bachelor's degree, the job requires a bachelor's degree in a specific field. They've broadened that to include in a range of degree fields that are directly related to the job. So it doesn't have to be one specific field. It can be different fields, as long as those fields are, you can show that those fields are related to the job, right? So it's not changed drastically, but there is some change, and this really makes a difference because there are some occupations in which a range of degrees are required, and usually those occupations don't get approved for a H1 because then USCIS comes back and says that it's not a specific, it's a range, and therefore we're not approving it. For example, I can give you an example of systems analyst, say, where it says bachelor's degree in engineering, math, physics, computer science is required, and USCIS would previously say that it was not a specialty occupation. Now, as long as you can show that that engineering degree, that math degree, that physics degree is related to the position, even if that's industry, it's still a specialty occupation. They usually go into the Occupational Outlook Handbook, which is a DOL publication, which is online, which you can check. They usually check that, and whenever there's something in that, in the Occupational Outlook Handbook (OOH), which says that a range of degrees are required, USCIS will generally send an RFE. So this, we can expect that more jobs will open up for a H1 and less RFEs, as long as we can show that the degrees are related. CAP exempt employers, they are narrowly expanding what the definition of a CAP exempt employer is. So for CAP exempt nonprofit research organizations or government research organizations, they have included a few more organizations into the CAP exempt employer category by replacing the term primarily research to research as a fundamental activity. So it means that the organization doesn't have to be only doing research. Even if they do other activities, as long as the fundamental activity is research, they can still qualify. In the past, their primary job had to be research. Primary mission had to be research. Now it's not so. It just has to be a fundamental or one of the main activities. The other change is bona fide position requirement, meaning the H1B petitions must now show that the offered position is a legitimate specialty occupation position, ensuring that the job meets all the criteria for the program. This basically means, in short, that, for example, if you're a consulting company, you have to show that you actually have specialty work, specialty occupation work available, meaning that you have to submit contracts and work orders. As you know, after 2020, after the Cessna versus IT-Serve decision, USCIS has not been asking for contracts and work orders. Now they will go back to asking that, but not to the extent that they were asking it before 2020, meaning that they will not ask for all 3 years to show that there is a requirement for 3 years, so show 3 years of contract availability. They will ask, at least to start off, you have a legitimate, contract, even if it's 6 months or whatever it might be for. But the contract requirement has come back. So this is significant because in the past CAP, we've seen that people have applied even without any contracts or anything, any client, especially if you're a consulting company, and they've still approved. Now, if you're not a consulting company, you still have to show that you have a bona fide requirement. So if you are hiring this person for not a contract position, but using them within the company, and you're not contracting them out, then you'd have to show that your company has enough business to require this. So you could show a tax return, you could show contracts work or that your company has with their clients in general, and you can show the volume of business in many ways. Maybe a list of clients, maybe your bank statements, maybe your invoices, to show that you actually have a need for this person. But this bona fide position requirement comes up mostly in a consulting scenario. Then they've also codified the site visits. So USCIS earlier always conducted site visits, but it was kind of voluntary. So you could either allow or not allow the officers into your office. Though, I mean, I don't see why you wouldn't, because if you didn't allow them into your office, they would write a negative report, and then your H1 would get denied or revoked, and there would be a black mark against your company. So now USCIS has actually codified their authority to conduct site visits, and they can, by regulation, deny or revoke petitions if a petition refuses to cooperate with their visit. Third-party requirements, they have specifically said for consulting companies, H-1B workers assigned to a third-party work site, the job requirements of the end client are important rather than what your internal job requirements are. This is also significant. So if you are hiring someone to work as a consultant, say at AT&T, and the position is that of a software developer, then they will want to look at what AT&T's requirements are to hire a software developer. And if they require a bachelor's degree in computer science, then it's a specialty occupation. Otherwise, it isn't. So you'd have to have much more accessibility to your client and get that information from your client, or get a letter from your client stating what the requirement is. So we're back with end client requirements, submitting end client requirements, or purchase orders which have the end client requirements. Another very, very important change, and this is, I think, a 360-degree range, which is basically the rule now allows H1B to be self-sponsored. Very important. You can file your own H1 even if you are a controlling partner in your company. Very
Wow.
important. This was never the case. So you always had to file through another company, or you had to file through your consulting company. This
Yes.
rule allows certain owners of petitioning entities to self-sponsor. Of course, there's a limitation on the amount of the H1, the period of the H1. You can get it for 18 months and then get it for another 18 months. And then I believe you can get it, for a longer period of time. But you have to keep in mind that though the H1 could be self-sponsored, when you're filing a green card, you could still have issues filing your own green card, because so this works for H1Bs, but when you have to file your green card again, you'll have to find an employer who's willing to sponsor you on the green card. But this is really important for a lot of entrepreneurs out there who are already able to do their own business, but are not doing it because they are they are restricted because of the existing H1B regulations, where you can't really sponsor yourself because there has to be an employer-employee relationship. So they have really um, widened this, loosened it, whatever you want to say. And even if you are managing your own business, as long as you are doing more than 50% of the job is the H1B specialty occupation job. If you're also doing the job of managing your company, which may not be a specialty occupation job, you can still do that. As long as the majority of the time you're doing, so over 50% is your specialty occupation job. So that is very, very significant. I left out the best part for, the last, but
For the last.
that's very important. And then there are other some more important rules for F1s, so revised cap gap rule. So now
Okay.
you will be authorized to work under cap gap or remain in status under cap gap until April 1 of the next year. Before it was October
Okay.
1st of the existing year, now it's April 1 of the following year. So that's also significant for F1s because they often see that when the H1B gets delayed, if it doesn't get approved by October 1st, then they have to scramble and go back into F1 status, file for, student status for another semester, file for OPT, CPT, whatever it might be to remain in status until the H1 gets approved. So they are taking that out. No need to because it's extended until the next year, April, and H1s don't take that long to get approved.
A little more
Uh,
relaxed.
Little more relaxed for sure. I mean, for the most part, 99% of the F1 students will not have to file for an extension to extend their cap gap. Another last um, change is maintenance of status documents. They want you to send your status documents at the while you're filing the initial petition itself. So they might ask for more documents with reference to your status. Right now, we just send the H1s and we don't necessarily send documents from the start of your entry into the US. So now they want all the documents, I think, from the entry of into the US from your first entry, and they might want all your pay stubs, all your W-2s to make sure that you maintained status throughout your. So that's something that they never used to ask for before. Maybe in random cases they would, but now they want that in every single case. So these changes, as you can see, they're a mixed bag. um, there's some positive and some negative, and that's to be expected. Um, so we have to wait and watch how this actually impacts consulting companies,
Yeah.
how this impacts individual H1B petitions, especially the self petitions, how they process them, whether there will be a lot of scrutiny and they have so much scrutiny that they won't actually approve any cases, or the scrutiny will be as it should be under the regulation, and they actually start approving these cases.
Let's see what the 2025 holds for us. But these new changes sound really good, and I really hope that this is going to benefit most individuals under H1B or who are planning to go for an H1B visa. So thank you so much, Prashanthi, for highlighting all those new H1B regulations and also these new changes for F1 students. Thank you so much. Thank you so much. It was great. And these are some of the latest updates, friends. I hope you note it down. And you can always go watch it right from the very beginning, whatever Prashanthi has shared. These are new updates that you wouldn't want to miss. And Prashanthi, we have some folks out there who have questions for us. I think we should address them before we jump into our Visa Bulletin questions for January 2025. And some of them are from your channel. So let's take them up quickly, please. So, Sudhinra. Sud, Sudhindra, sorry if I'm pronouncing your name wrong, but he says, hello, I do have a query. My I-129 was approved on November 25th. I'm still waiting for I-797 form. So will this new H-1B changes affect my case?
No, this is only going to be from January 17th. That is, cases filed after January 17th will have to be filed under this new regulation.
All right. Thank you so much for addressing this one, Prashanthi. Now let's take up Shree's question. Hi, H1B petition is applied on November 24th for extension. Is this third party placements through consulting apply for H1B applications applied after January 18th, or will it still apply for already applied ones?
Good question. It should only take. It should only be. I don't see that it is retroactive, but I can cross check. It should only be applicable for petitions that are going to be filed after the 17th. But again, I'll cross check. And then I'll let you,
Sure, sure.
Nipasa, I'll let you know, and then you can um, let Sri know.
We can
But
leave
as far
comments.
as as far as I know, regulations are usually not retroactive. They're always only come into play once they've been once they're active, once they're published
once
and the
they're
comment
active.
period and the 30 days is over. Yeah.
And these
But
changes are
it's
going to be effective on January 17th,
17th,
2025.
17th. Correct, correct. But if it's otherwise, I'll let you know.
Okay, thank you, Shri, for commenting. And if you have any other questions, keep commenting. And otherwise, you can join us on this conversation, folks out there, by dialing this number 425-436-6335, and the access code is 988-888. And Abhishek, hi, thank you for joining us. Charwak, we will address your questions, but please stay with us for now. So, Prashanthi, let's get to our visa bulletin for January 2025. We have some questions also, so let's jump right into them. So, given the significant retrogression in the EB2 and EB3 categories for Indian applicants, what strategies can individuals take to potentially expedite their visa process?
Nipasa, shall we go through the January visa bulletin first, just to give people
Sure,
an
let's
idea as
let's do
to?
that.
Okay, so so basically, starting with the employment-based categories, for dates of for filing, there's been no change. Um, for final action date, there has been some advancement for both EB2 and EB3 categories. Let's go into that. So final action date, EB2 has moved up by 2 months to October 1. China is advanced by 1 month to April 22nd, 2020. All other countries advanced by 2 weeks, so not a big leap, but still something's better than nothing. It's moved to April 1, 2023. So India moved by 2 months, China by 1 month, all other country by 2 weeks for EB2. For EB3, India moved up by 3 weeks, 2012. China moved by 2 months to June 2020, and all other countries moved up by 2 weeks. So again, India 3 weeks forward movement, China 2 months, and all other countries 2 weeks. So you see that EB2 and EB3 both have moved forward moderately, not drastically, but any forward movement is good. EB3 also, there's been an advancement. India moved up by 3 weeks to December 1, 2012. All other countries, except of course for China, advanced by 1 week, so very short advancement to December 8, 2020. And then going to the family-based categories, uh, India, China, and worldwide advanced by 1 month for F1. That's unmarried sons and daughters of US citizens. Now they're on November 22, 2015. Philippines advanced only by a week to 2012, March 8, 2012. F2A, spouses and children of permanent residents. Again, Mexico advanced by 1 month, and India, China, and other countries advanced by 3 weeks. For F2B, that's unmarried sons and residents. For F2A, the only change is Mexico. Married sons and daughters of US citizens, Mexico went up by 1 month, Philippines by 2 months. All other countries went up by 2 months as well. Of course, not US, not India. It's the most backlogged, which is brother and sisters of US citizens. Philippines went up by 3 months. India went up by 1 month. Any advancement is good because it's very rare. Now that was the final action date table, but but the dates for filing table, which we presently can look at, has also changed for family base. So Mexico went up by 3 months. India, China, worldwide. For F2B, Mexico went up by 3 months. That is unmarried sons and daughters of permanent residents. For F3, married sons and daughters of US citizens, India, China, and worldwide went up by 3 months, which is a good advancement. And brothers and sisters, that's the F4 category, which we were just talking about, 5 months to 2008. India advanced moderately by 2 weeks to 2006. So always look at the dates for filing tables, because those, if USCIS is allowing you to use those tables are usually ahead of the final action date table. It's just that you won't get a green card immediately, but you'll be able to file for a 485 and be in a 485 status. and get the advanced parole and employment authorization as well.
Right. Any advancement is good, and this is very rare to see. So all these good advancements are good news, and thank you so much, Prashanthi, for going through the visa bulletin for January 2025 for us and highlighting those important changes in the advancements for both the dates. So now let's go to our questions, if that's fine. But before that, Sudhindra has said, "Thank you, Prashanti ma'am. This eased my anxiety. Kudos to you both." Thank you for your question and thank you for that, Sudhindra. So going to our question, we see the significant changes in EB1 and EB2 categories for applicants. So maybe if you could tell us a few strategies that individuals can take to potentially expedite their visa process.
Right. So we see, even though there has been some forward movement, there's still retrogression for EB2 and EB3 for Indian applicants and Chinese, people from China as well. Um, so, I mean, in order to navigate this, there's some things we can do. There's not a lot we can do, of course, other than advocacy to change that. But some things is to see if you qualify under EB1. So if you possess extraordinary ability, or you're an outstanding professor or researcher, or you've worked as a multinational executive or manager, you can consider applying under EB1 or see what you can do to make yourself eligible for EB1. You can file under NIW if your work is substantially intrinsic to the US and helpful to the US. Then under EB2, you can file under national interest waiver. The advantage of this is, even though it's still EB2, you can bypass the labor cert process and thereby gain some time, because the labor cert process takes more than a year now. Uh, Always make sure you file concurrently. If your dates are current, don't file the I-140 first and then wait. I mean, you could do that, but in order to speed up the process, you should file both the I-140 and 485 together, because by the time you get the I-140 approved, maybe your dates will no longer be current. So concurrent filing, even even if the I-140 gets denied and you lose your money, concurrent filing might be the way to go, especially if the dates have become current. Cross chargeability. If your spouse was born in a different country with a less backlog, so if she's not born in India or China, he or she, then you might benefit from your spouse's countries of birth. Always make sure you cross check your spouse was not born in this country as you. And last but not the least, always maintain your non immigrant status. Ensure your current visa remains valid so that while you're waiting, you don't accrue unlawful presence and then have to leave the country.
Thank you. Thank you so much, Prashanti, for addressing that and for highlighting those changes. And before we go into our next, let's take up Prabin's question. Does this rule apply for transfer and extension? I think he's talking about the new H1B regulations,
It applies to everyone. Transfer, any H1 that you file, cap, extension, transfer, amendment, anyone.
but after the date, January 17th, 2025, Prabin. Thank you for your question
Correct.
and thank you for participating. Let's go on to our next question now, Prashanti. So, how does the advancement in family sponsored categories, such as F1 and F3 categories for Indian applicants,
Yeah.
impact the expected wait times for green cards?
Well, so unfortunately, as we've seen, right, there's no significant advancement. There is advancement of 2 or 3 months, but as you've seen, F4 categories still remain backlogged. So I would say, in order to prepare to, so that when your case gets current, what you need to do is document ready, right? So keep all your documents ready, especially your birth certificate, marriage certificate, those kind of documents. Um, you have to keep them ready. So that's one thing to keep in mind. Other thing is stay informed. Regularly check the monthly visa bulletin for any changes in priority dates. uh, and keep yourself updated. Don't miss. Sometimes the priority dates are available only that 1 month, and then they become unavailable the next month. So get an automatic email, and you can register to do that so that you get it into your inbox whenever there is a new visa bulletin. That way, you won't forget to check. The reason I was talking about document readiness is you might not have your birth certificate, you might not have your marriage certificate, perhaps your birth certificate was never registered, then you need a non availability certificate. And this is since you don't have it and you don't have control over how long it'll take because this has to be done by the registrar of birth and deaths in the town that you were born. Do that in advance and keep them ready. And then, of course, as I said earlier, consider alternative paths between the employment based and the family based and see which one has shorter times and apply for both if you're able to, right? So that's another way to kind of be prepared despite the retrogression.
Thank you so much, Prashanthi, for highlighting that as well. And family sponsored categories, I think folks out there are pretty tensed how to go about this, and especially with all these backlogs that have been significant all the while. And I think thank you so much, Prashanthi, for addressing this again.
You're welcome.
Let's go on to our next question now. Let's take up this one. Can you explain the implications of the EB5 category, showing a favorable environment for investors? And what does this mean for those considering applying for an investor visa?
So while the visa bulletin shows that the dates are pretty good and
Mhm.
current for most countries, including India, um, you have to keep in mind that the processing times for EB5s are not good. So while the priority dates might be available, your processing times are about 4 years just for USCIS to process it, which is ridiculous. I don't know why they're doing this I guess they're doing this because they don't want to give out EB5s. There's no other reason. They're trying to
Mhm.
stop the EB5s or kind of stall them or reduce them, whatever it is. So processing times are really, really long. So you have to keep in mind the processing times when you look at the total time taken to get an EB5. And while you might, if you're outside the country, especially, and you're investing that kind of money, and if the processing time is taking 4 years plus, even if your priority date is available, and then takes another 2 years to get for it to get a permanent green card by removing conditions, then you're already looking at 5 to 7 years, and then we don't know what the priority dates will be then, right? We're only looking at the priority dates now. So do it, but keep in mind all these things with reference to processing time and how that might impact you. And keep in mind the requirements of, the 1+ million and the 800,000, depending on where you're investing, and that you need to create and preserve during this time 10 jobs, 10 full-time jobs. So you have to continue to have those 10 full-time jobs. And if you're using a regional center, make sure that you do your due diligence to make sure that the regional center has, has good, uh, good investments. So these are a few things to keep in mind, I think.
Thank you so much, Prashanthi. And folks out there, I would like to tell you that you can also join us in this conversation by dialing this number 425-436-6335. You can join us, and when they ask for the access code, dial in 988-888. Once you're in, you just say hello and we will be able to hear you. And otherwise, folks out there, this is Attorney Prashanthi Reddy, and you can also have a one-on-one consultation with her. And her phone number is there on the screen. Her number is 212-354-1010, and you can also email Attorney Prashanthi Reddy, and that is Prashanthi at reddyesq.com, and go visit www.reddyesq.com to get to know more about Attorney Prashanthi Reddy. Let's go on now, and we have Arpita also who has joined us with the questions. Arpita, please stay with us. We will address your questions a little while later. Prashanthi, with the visa bulletin, showing current priority dates of most employment-based categories for other countries, that is rest of the world. What factors could contribute to these variations in processing times between regions, if you have anything to highlight?
Yes, the times. I mean, the priority dates are definitely going to be different depending on which country you were born in. It's based on country of birth, remember, not country of citizenship. First of all, it depends on the demand and supply in your particular country. For example, because everyone gets only 7% of the total green cards, every country gets 7%. So, for high demand countries like India, the wait time is much longer due to the country caps, right? Also, each category has again a cap. So, depending on which category you're filing in and what is the demand in that category. So, for EB1, the demand is less. So, the wait time is less. If you're EB2, EB3, the demand is higher. This also, the efficiency of the USCIS in processing these, administrative efficiency also makes a big difference. So processing times, especially if you're filing outside the country, your wait times will differ depending on the consulate that is processing your green card. Even though part of the processing takes place here, the final immigrant visa petition is processed for India, example in Bombay, and Bombay has a wait time because they have only so many slots available for interviews. So that could add to your processing time as well, depending on which consulate. And also USCIS often delays processing of cases. So depending on at that particular time, what USCIS processing times are, that could also uh, account for variations in processing times. So I think all these have an effect on your processing time. Hello, Nipasa. I think we lost you. Oh, there you are.
Ma'am, control here. I'm trying to get in contact with Nipasa again. Let me see.
Okay.
One
Okay.
minute, ma'am. 1 minute, ma'am.
I think she's back.
Nipasa, you okay? 1 minute, ma'am, please. Sorry.
Sure.
Sorry, folks.
No problem.
Sorry, guys.
Thank you so much, Prashanthi, for addressing that for the rest of the world. I think there was some internet lag. I had to rejoin. But thank you so much, folks, for staying with us. This is Immigration and Jobs Talk Show. I'm Nipasa Pradhan with our guest for today, Attorney Prashanthi Reddy. So it's been great having your questions, and I think we're going to address them in a little while. But Prashanthi, if you could also, tell us um, how do the changes in the visa bulletin also affect the family reunification process, especially for siblings of US citizens, the F4 category, which you had touched upon a little bit earlier. But what steps should families take to prepare for possible delays and advancements?
Yes, so the F4 category is severely backlogged for most countries and especially for India, as we discussed. And I guess the only thing we can do is timely file your I-130 petition as soon as possible so that you can, be in the window. Um, Maintain communication, keep in regular contact with NVC if you're outside the country. That's a National Visa Center to update them on any changes that might have taken place, right? Since it's taking 20 years, you might have had children, you might have gotten married, right? Unfortunately, sometimes the sponsor might be no more as well. So you have to continue to maintain contact with NVC and update them on any changes that are taking place. Also, explore other options. And you might want to think whether you want to file an I-130 or not at this point of time, or you have other ways of coming into the country or filing a green card if you're already in the country. Consider filing a B2 if you want to come and meet your country, your family members for a short period of time, or consider another non-immigrant petition like a student visa or coming to work here so that you can, be you can reunify with your family members. So alternatives are should already always be looked at. If you are filing an I-130, remember it might be better not to file it if you're going to file a non-immigrant petition. That requires you to have intent on not to immigrate. So for example, like a B2, an F1, you may not be able to file an I-130. You might have to hold off on that and file this first and then file an I-130 once you get onto a visa which allows dual intent, like a H1. So these are strategies that you have to think about considering the long processing times for an I-130. And I think an attorney can really help you and advise you on strategizing on the best path forward.
Absolutely. And folks out there, you should definitely contact attorney Prashanthi Reddy, and you can email her at prashanthi@reddyesq.com. And moving on, Prashanthi, if you could also tell us what potential legal challenges or policy changes could impact the visa bulletin and immigration trends in the upcoming months. We already touched upon the latest updates on H-1B regulations, but anything else you want to add?
Well, with the new administration set to take over in January, um, we have to see. Visa limits are established by the law, right? And unlikely to change immediately. However, there might be legislative proposals or bills like the Fairness for High Skilled Immigration Act that could be reintroduced. You never know. For years and years, nothing has happened. I don't expect anything will happen under the Republican controlled House and Senate legislature, but let's wait and see. You can never say never. This H-1B regulation came out after so many years. That will happen. Who knows? Policies can always change for governments, right? Um, right now, it seems like the Republican Party under Trump is not pro-immigration, but I'm hoping that they'll surprise us and change their policy. And the Elon Musk and people who have Trump's ear might have some influence over the present government, and I'm hoping that they'll have enough influence to bring about or bring about some positive changes, at least with reference to business immigration. Court decisions can often influence immigration policies and procedures. I am not sure in what scenario this can go before the court, but if it does, and if they um, then if they or if the judge decides that the visa numbers, the way they're counted wrong, and maybe family members should not be given a separate visa number, if that's something that they can decide after looking at the interpreting the regulation in the Immigration and Nationality Act, then that's a possibility as well. But we have to wait and see.
For sure, Prashanthi. And I think we should also address some of our questions from our viewers. So let's take Abhishek's one. I noticed the January 2025 visa bulletin has some movement in EB categories, but it's not as much as I expected. Why is the movement so slow for certain countries?
Because the demand is so high and they don't want to release numbers quickly. They want to wait and see because we have the entire year uh, ahead of us. So I think they're doing it slowly. That's for that reason. They want to wait and see.
Yes. Thank you,
If they are,
Abhishek, for your question.
if there are visa numbers still available, then you can see likely that there'll be some movement towards the end of the year, maybe August, September, because the year end is October.
Right. Let's hope for the best. Thank you, Prashanthi, for addressing this. Let's take up Charwak's question. What are the key differences between final action dates and dates for filing applications for immigrant visa applicants, and how do they impact the application process?
Um, right. So the final action date table actually is the date when your priority date is available. The dates for filing table is something that the Department of State introduced to allow you to file applications in advance, because the way they um, the way they calculate it is that they're hoping that by the time you file and by the time the case gets processed, your final action date, priority date, will actually be available. So that's how they calculate it. So it's usually dates for filing are, a few months in advance or maybe a year in advance of your final action
Mhm.
date table. The advantage of the dates for filing table and the huge benefit that it has is that it allows you to file your adjustment of status early, before your actual date becomes available. And this allows you to file for a 485 and allows you to maintain status without having to maintain a non-immigrant status. So it allows you to continue to be on 485 for years together and have EAD and advance parole. That has been a boon for a lot of people um who have suffered due to the unavailability of visa numbers, because maintaining a H1 for so many years is very difficult, because a H1 is a very stringent visa status to maintain.
Right. Thank you so much, Charwak, for your question, and thank you, Prashanthi, for addressing this. Let's go on to our questions from our YouTube channels first, and then maybe we can take up Arpita's question. So, Control, if you could display the first one. All right. Meanwhile, Prashanthi, like I have one more question to go. So, given the significant disparities, between employment-based and family-sponsored categories, how should applicants prioritize their visa strategies to align with their personal and professional goals?
Right. So this is again similar to what we discussed with reference to retrogression for the family-based F4 category, and how you should maybe look at alternatives. Uh, I guess it's the same for this. When you're deciding between, I mean, most family-based categories, immediate relative, of course, is a no-brainer, because if you are a U.S. citizen child under 21, or if you're a spouse or a parent, there is no visa numbers required, so you can file immediately. So obviously, if you're one of those, would definitely file under the family-based immediate relative category. But even if you're a permanent resident spouse, you might consider filing that rather than doing EB1, EB2, or EB3. So you have to assess what are the priority dates for each, and evaluate. First, assess your eligibility for each category and see what you qualify under, and then evaluate the wait times categories that you qualify under, and file. You can no one you can file for both under certain circumstances, but again, I think you need to speak to an attorney to see if it's a good idea to file under all categories, or just stick to the categories that are better, and also be flexible, be ready to change or file under the a different category if this category gets backlogged. So always be flexible, be prepared in a month's notice to file under your that particular category. It happens to jump forward. So yeah, these are the
Right, right.
few things to keep in mind. Assess your eligibility, evaluate your wait times, of course, consult with an attorney, and stay flexible so that you can pivot to the other
Absolutely.
category when required. And when I say pivot, I also mean
Yes, yes.
pivoting between employment-based categories, between EB2 and EB3 as well. And
Mhm. Thank you so much.
also, Nipasa, in order to pivot, you have to know there is something called changing of the underlying basis. So you don't have to file a new 485. If you file under EB2 and you want to pivot to EB3, you can just ask USCIS to change the underlying basis of 85. And this certain situations is possible even between a family-based and an employment-based category as well. So you might not have to file for a new 485. You can ask USCIS to pivot your 485 to the family-based category. But again, consult with an attorney before doing that.
Absolutely. Thank you so much, Prashanthi, for addressing all these and highlighting the important things to keep in mind. And folks out there, it's always best to consult with an attorney. So it would be great if you could also consult with one, and why not Attorney Prashanthi Reddy? So you can email her about your case, and her email address is prashanthi at reddyesq.com, PRASHANTHI at the rate REDDYESQ.com. Thank you. And let's go ahead with our questions now from our YouTube channel. So, Control, if you could display it, please. Um, the first one is: are these rules applicable for already selected H1B applicants whose petition is not yet approved? And please give information about the H1B petition delay happening right now. Prashanthi.
So no, as we discussed, these rules should not be applicable for H1B petitions that are already in pipeline. They should only be applicable for petitions that are going to be filed after January 17th, as per regulation. And again, I had said that I would cross check that and get back to you with reference to if there's something written in the present regulation, because it only came out yesterday, makes it retroactive. In
Yes.
general, it's only regulations are only uh, are take into effect from the date that it's published, or the date that they say it will take into effect.
Okay. Thank you. Thank you so much, Prashanthi, for taking
And
this up for Indhu.
Nipasa, about the H1B delays happening right now. Um, in my
Yes.
office, I'm not really seeing those delays, but perhaps you are. Perhaps this is with reference to your particular case, and there could be some reason for it. Maybe you're going to get an RFE, and that's why they're taking longer to respond. I mean, if you want to overcome that, just convert your case to premium processing. If you can do that, I know it's a lot of money, but if you want to get approved faster, that's definitely one way of doing it.
Right. Right. Thank you. And for an RFE, you have around 45 days to respond to it, right? Or 60
Actually,
days, is
more
it,
than that.
Prashanthi?
Depends, but
Okay.
usually the maximum time is 80 something days. So there's plenty of time to respond to an
Okay.
RFA.
Okay. All right. Thank you so much, Prashanthi, for taking this up for Indhu. And I hope this was very helpful for you, Indhu. And even otherwise, you can always contact Attorney Prashanthi Reddy. She could guide you personally on your case. And that is prashanthi at reddyesq.com. Let's go on to our next question. This is also on our YouTube channel. How long does it take to get a receipt if you have filed an H1B transfer in premium processing? New employers sent the FedEx last Friday, and it dispatched on this Monday. Still, after 5 days, don't have a receipt number. They have filed in premium. Is there a delay going on nowadays? Never faced this much delay in premium transfer. Is this normal?
Yes, because it could be that, usually what happens is I would like to advise that, file online because you get a receipt immediately if you file online. So try to make that into a practice rather than FedExing your case to USCIS. Of course, I understand in some instances you cannot file online because you have a H and you want to file the H1 together so that both process together. And in that situation, you cannot file online because you can't file a H4 online. But otherwise, I would suggest file online and you'll get the receipt immediately. But with reference to premium processing, you should usually get an email within the first 1 week of filing with the receipt. But I'm not surprised if you didn't. I wouldn't panic. Sometimes they don't, and that doesn't mean that they're not processing your case. It might just mean that they as yet. Um, and I've noticed premium processing, they do, it's supposed to be 30 days. They never take the 30 days. It's usually processed within a week or 10 days. The only thing to make sure is that FedEx was delivered and that you have confirmation of the delivery. After that, I wouldn't worry too much about not getting the receipt within the first 5 days. Wait and see.
5 days. Okay.
Not
Thank you
yet
so
time
much
to
for
panic.
not yet time to panic. Yes. Shaba Kahal, thank you so much for your question, but I think you'll just have to be a little more patient and wait. Thank you, Prashanthi, for addressing this one. Let's go on to our next control. If you could display it, please. This is from Pradeep. Is Indian Chartered Accountants considered for H-1B specialty accusation for accountant job? I have only Indian Chartered
Occupation,
Accountant
yeah.
certificate.
Right, occupation, I guess. Um, CAs
Yes.
can qualify to work as accountants. They cannot they cannot work as CPAs in the US, so that they cannot file taxes, but they can work under a licensed CPA as an accountant. And yes, an accountant is a specialty occupation, and yes, you can file a H1 for an accountant.
All right. This is good news for Pradeep then. Thank you. Thank you, Prashanthi, for taking this one. I think we have one last one from our.
And the other question he had was, if I only have an Indian Chartered Accountant certificate, is that sufficient? You require a bachelor's degree, your degree in accounting, but your chartered account certificate, along with your bachelor's degree, if it is in can qualify you, or make it, if you send it to the evaluator, which your attorney will do, they can consider it to be the equivalent of a bachelor's degree in accounting. So yes, using that, it's possible to qualify as an accountant.
It is. It is. So the evaluation is much needed since he must have done it from an Indian institute. I mean, his studies. So evaluation is a must before that, right? Thank you,
Correct.
Prashanthi, for taking this up.
Yes.
This one is, I think, our last one. I have never traveled to US and working with Company A. My H-1B petition got approved with Company A. Now the project is being wrapped up and Company A is not willing to send me. Can I transfer my H-1B approved petition with Company B and travel to US? If yes, what will the process be and how long does it take?
Yes, you are cap exempt in this situation because you have previously filed a H1, even though you worked. But of course, or how they exempt is often the interpretation of who is cap exempt, and often change. USCIS right now will consider to be a cap exempt case, but moving forward, if USCIS gets more strict with reference to the interpretation of who is cap exempt and who is not, they might insist that in order to be cap exempt, you have to actually start working for the company. But as of now, yes, you are cap exempt. You can file for another H1 and then get your visa. Once you get an approval, if you already have a visa, you can use the existing visa and the new H1B approval to travel as well.
Okay. All right. Thank you so much, Prashanthi, for addressing this one, and thank you, MD Nazim, for joining us with your question. And I hope that was, I mean, good. Good. I mean, if you have more questions, you can keep commenting. Thank you. And Prashanthi, maybe we could take up, if you still got a little more time, we can take up Arpita's question.
Sure, one more
I am an
question. Yeah.
Indian national. All right. I am an Indian national currently working in the US on H-1B visa, and I'm interested in applying for a green card under EB3 category. However, I'm concerned about the per country limit and potential retrogression. Can you explain how the EB3 category works and what are the specific requirements and procedures I need to follow to increase my chances of a successful application and given the current visa bulletin?
Just that you apply under EB2 category if you qualify. Just to let you know, in order to your job should require either a master's degree or a bachelor's plus a 4-year bachelor's plus 5 years of work experience. So if you qualify under EB2 and you file your I-140 under EB2, then if EB3 becomes available or shoots ahead, then you can always file your I-140 under EB3. This way you can have an EB3 as well as an EB2 application. This gives you more flexibility, and you can use either or, rate if depending on the dates. If you file under EB3 to start off with, if you file your labor cert under EB3, then you will not qualify under EB2. So if you are EB2, and then you can always, uh, downgrade to EB3. But if you don't qualify for
EB3.
EB2, which may be, yeah. So if you don't qualify though for EB2, and you have, that's why you have interest in filing for EB3, then by all means go ahead and do it. The requirements are the same. You have to file a labor cert. You have to have a bachelor's degree, or if you're doing EB3 under um, specialized workers, then you can have even less than a bachelor's degree. File the labor cert first, then once it gets approved, you have to file the I-140.
Thank you so much, Prashanthi. And Arpita, all the best. I'm sure you will figure out what's going to be best for you. And I think it's always best to consult an attorney. And why not contact attorney Prashanthi Reddy? You can call her directly, and her number is 212-354-1010. You can also email attorney Prashanthi Reddy. Her email address is prashanthi@reddyesq.com. And please go visit www.reddyesq.com to get to know more about attorney Prashanthi Reddy and the law offices of Prashanthi Reddy. Uh, Thank you so much, Prashanti. It was great discussing, the latest updates on the new H-1B regulations and also the Visa Bulletin for January 2025. Thank you so much for joining us.
Thank you.
Well, I think it's going to be Christmas coming Wednesday. I still hope that I'll be able to see you, but even if not, here's wishing you Merry Christmas to you and your whole team out there.
Thank you. And I like to wish you and the audience that's listening happy holidays as well.
Thank you so much, Prashanti. Thank you. This is it for now, folks out there. Thank you so much for joining us. And that's all we have for today's discussion. Yes, if you found this session helpful, please don't forget to like, share, and subscribe to Immigration and Jobs Talk Show. And also hit the bell icon so that whenever we have discussions like these, you are notified. And yes, don't forget to follow us on social media because we are there on not just YouTube, but also on Facebook, LinkedIn, and on X. So yes, follow us for updates on future episodes and webinars. And remember to stay informed. It is the first step, to making confident decisions about your immigration journey. Thanks for watching and stay tuned on Immigration and Jobs Talk Show because we got a lot more coming up. And also look out for our 4 p.m. Show, which is Daily Immigration Dose with my co-host Sam. So yes, see you then. For now, keep on having a great day ahead.